When two trademark owners agree there's no likelihood of confusion between their marks, shouldn't that be enough to satisfy the USPTO? Well, not always. In a recent precedential decision, the Trademark Trial and Appeal Board rejected a consent agreement between two parties using the name Gasparilla, finding that the agreement wasn't enough to overcome a refusal based on likelihood of confusion. I'm Scott Hervey, a partner at Weintraub Tobin, and I'm joined today by my partner, Richard Buckley. We're going to talk about the TTAB's decision in Ye Mystic Krewe of Gasparilla and what it teaches us about how to draft a consent agreement that will actually work on today's installment of the briefing. Richard, welcome back to the briefing. Good to have you.
Great to be back.
Richard, are you familiar with the Mystic Krewe of Gasparilla and the Gasparilla Pirate Festival?
I'm not. I've been to Tampa. I've litigated a case in Tampa, but somehow the Mystic Crew of Gasparilla escaped me,
I have been to
unfortunately.
Tampa. I have never seen or heard of the Mystic Krewe of Gasparilla or the Gasparilla Pirate Festival until this case. But I don't know. It looks kind of, do my research. It looks kind of interesting. So we'll see.
I think a road trip is warranted at
I'll
some
have to get
point.
my pirate's patch and a peg leg and
Well, anyway, the applicant in this case, Ye Mystic Crew of Gasparilla, is, as we suggested, a Tampa-based organization that's been around for over 100 years. They're famous for organizing Tampa's annual Gasparilla Pirate Festival, a massive civic event that celebrates the mythical pirate Jose Gaspar or Gasparilla.
right. And Ye Mystic Krewe filed an application back in 2021, a little bit late to the party if they've been around for over 100 years, but nevertheless, in 2021 to register the mark Gasparilla in standard characters for a variety of goods, including cups, mugs, and glassware in International Class 21, and shirts, hats, and other apparel in Class 25. The application was initially based on intent to use. Again, strange since they've been around for 100 years, but okay. And later amended to the supplemental register once the organization began using the mark in commerce.
But the USPTO's examining attorney partially refused the application, specifically for the goods in classes 21 and 25, based on a prior registration for Gasparilla Treasures. That registration covered, among other things, beverage, glassware, hats, shirts, and sweatshirts.
Right. The examining attorney issued what's called a Section 2D refusal. That's a refusal to register a mark that's the subject of a trademark application based on likelihood of confusion with a prior registered mark. Here, the examining attorney found likelihood of confusion between the marks. Because the marks shared the identical dominant term, Gasparilla, and because the goods were overlapping, the examiner concluded that consumers were likely to think that the products came from the same source.
After that refusal was made final, Ye Mystic Crew asked for reconsideration. They told the USPTO that they had actually licensed their Gasparilla mark to the owner of the cited registration and would soon submit either an assignment or a consent to registration agreement in order to resolve the issue. But they didn't attach anything at that stage, so the request for reconsideration was denied.
Right. I don't know. I think that was a little mistake there. Okay. So when they appealed to the TTAB, they finally submitted a trademark consent agreement between themselves and Gasparilla Treasures, the registrant, and they asked that the refusal be withdrawn. The board remanded the application back to the examining attorney to consider the trademark consent agreement. But after reviewing it, the examiner said that it was a naked consent and refused registration. And that's what led to this particular precedential opinion because the board took a close look at the trademark consent agreement and explained why it wasn't enough to allow Ye Mystic Krewe of Gasparilla's mark to be registered.
Before we get to that, it's worth remembering what the USPTO says about consent agreements. Under TMEP Section 120701, a consent agreement between trademark owners can carry great weight in overcoming a Section 2D refusal if it reflects a reasoned assessment of the marketplace.
Right. That means that the agreement should explain why confusion is unlikely and include specific measures the parties will take to avoid it. Things like having different logos or different packaging or limiting trade channels or agreeing to cooperate if confusion ever occurs. But a naked consent, as the TMEP calls it, is one that simply says, we don't think confusion will happen without explaining why. And as sexy as a naked consent may sound, those get little or no weight at all.
Exactly. The Federal Circuit has emphasized that a consent's value depends on its content. The more detailed and realistic it is about marketplace conditions, the more persuasive it becomes.
So, how did Ye Mystic Cruise agreement measure up? Well, as you can see from the results, not well at all. The board said that the agreement was brief, about a page long. By the way, I don't know how a lawyer can say anything in one page, and lacked meaningful detail. Basically, it said the registrant consents to the applicant's use and registration. The parties believe there is no likelihood of confusion, and if confusion ever happens, they'll take commercially reasonable steps to fix it.
The board called that a naked consent because it didn't explain why the parties thought confusion was unlikely or how they planned to avoid it. And when the board looked at the actual marketplace context, the agreement fell apart. The marks were highly similar. In fact, Gasparilla was fully contained in Gasparilla Treasures. The goods were identical or legally identical, the same shirts, mugs, and hats, and there were no restrictions on trade channels or consumers.
Right. The board noted that when marks are this close and goods overlap, the degree of similarity required to find confusion is low. Consumers could easily see Gasparilla as a shortened version of Gasparilla Treasures or assume both come from the same source.
The board also pointed out that the agreement didn't say anything about using different logos, different trade channels, or separate fields of use, nor did it provide any meaningful history of coexistence. Even if the marks had been simultaneously used since their claimed dates, that would only be about a year, too short to prove that confusion had not occurred.
Ultimately, the TTAB concluded that the consent didn't outweigh the other DuPont factors. Those are factors that a court will take into account when determining likelihood of confusion, all of which pointed towards likelihood of confusion. The board wrote that there was no sufficient basis in the consent agreement explaining why confusion is unlikely where the identical goods are sold to identical consumers in identical channels of trade under highly similar marks. The refusal was affirmed for the class 21 and 25 goods, but the application was allowed to proceed for its other classes.
This case is a good reminder that a consent agreement isn't a magic bullet. When the marks and goods are identical, you need more than mutual assurances, you need substance.
Right. To be persuasive, a consent agreement should show the work. That means that it needs to explain the party's reasoning and include concrete steps for avoiding confusion. In this case, the court noted that there is no per se rule that a consent, whatever its terms, will always tip the balance to finding no likelihood of confusion. And therefore, it follows that the content of each agreement must be examined. So, here's some practical tips based on this decision when it comes to drafting an enforceable consent agreement. So, spell out the differences, explain how the marks are used differently, different logos, different trade dress, or different marketing. Address trade channels. If the goods and services are sold through distinct outlets, say so clearly. Include restrictions. Agree not to use the marks on each other's goods or in the same regions or same marketplace. Show coexistence. If the parties have coexisted without confusion for a period of time, document it with dates and with evidence and plan for the future. include cooperation clauses detailing how confusion will be handled, who monitors it, and what steps each party will take.
The TTAB also made a subtle but important point. Just because two parties want to coexist doesn't mean the public won't be confused. The board's job is to protect consumers, not just honor private deals.
Exactly. Or as the Federal Circuit put it in DuPont, a naked consent may carry little weight, but a detailed, thoughtful agreement that reflects real world marketplace can carry great weight and can often be the deciding factor. Well, thanks again to my co host, Richard Buckley. Richard, it's always great to have your insights, always a pleasure.
It is always a pleasure, Scott.
And thank you, our listeners, for joining us today on the briefing. If you found this episode helpful or interesting, please take a moment to subscribe, like, and share it with your network. We'd also love to hear from you. Leave us a comment or a review and let us know what topics you would like us to cover in future episodes. I'm Scott Hervey. I'll see you next time on the briefing.